We can start. Welcome back, everyone. It is now the moment of our second panel, Perspectives from Law, Cross-Cutting Issues, which is chaired by a scientist with 4 outstanding lawyers as panelists. At the end of this panel, we will have time for some questions. So again, please do not hesitate to use the Q&A function at the bottom of your screen to post your questions. And also another thing, the first question will be by one of the students, of the participants of the summer school, just also for Mario to know. And so now I have the pleasure to introduce you the chair of the second panel, Professor Mario Martino. Professor Martino is the head of the Department of Science, Technology and Society, the coordinator of the Inter-University Doctoral Course on Sustainable Development and Climate Change, and associate professor in hydrology at the University School for Advanced Studies, IUSS Pavia. His research interests include risk modeling for weather-related hazard, applications of risk models in the insurance and reinsurance industry, assessment of the socioeconomic impacts of climate change and disaster risk finances mechanism. He teaches courses on natural hazard risk modeling to undergraduates and to master PhD students. So Professor Martina, many thanks for joining us. Please, you have the floor.
Thank you very much, Ivano. Thank you. And hello to everyone. It's really an honor to be here, to be chairman of this second panel. It is a really interesting panel after the first one, where from a perspective, the perspective of a climate science, you see some problems related with the climate change and other aspects like policies. While in this second panel, we will adopt a perspective from law. And we have 4 speakers to talk about the, I would say, the use and the impact of science in 2 main areas. In the first part, we have 3 talks. In the first part, there is just a general introduction and general insight on the use of science in climate change litigation by Joana Setzer. Joana is an assistant professorial research fellow at the Grantham Research Institute of Climate Change and Environmental at London School of Economics. Her main areas of expertise are climate litigation and global environmental governance. She leads the Grantham Research Institute's Climate Change Laws of the World project, the most comprehensive global resource on climate policy, legislation, and litigation. Joana is currently serving as a contributing author for Working Group 3 of the Ipcc 6th Assessment Review. She regularly advises a range of international governmental and non-governmental organizations. So Joana will give us a general insight on the use of science on climate change litigation. The second talk will be given by Annalisa Savaresi, and he will touch a different aspect, is the aspect of the human rights-based climate change litigation. So it touches another perspective, the perspective of the human rights and the use of science in this context. Annalisa Savaresi is Associate Professor of International Environmental Law at the Center of Climate Change, Energy and Environmental Law at the University of Eastern Finland, where she serves as Director of the Joint Nordic Master Program in Environmental Law. She holds a research post at Stirling University in UK and a visiting professorship at Sant'Anna School for Advanced Studies in Pavia and the University of La Sabana in Colombia. Annalisa is an expert in climate change law with 20 years experience working with international and non-governmental organizations. And she has written extensively on emissions from land uses and measures to reduce these, and on the relationship between human rights and climate change law. In the third talk that will be given by Jason Reeves and Deepa Sutherland, we will touch the second aspect, the aspect of the impact of science on corporate due diligence related to climate change. So human rights and the impact of science on corporate due diligence. And this talk will be given by Jason Reeves, who is an English solicitor and licensed attorney in Texas. He has a unique experience of practicing law in US and England, and he focuses on complex insurance disputes in England, the US and other jurisdictions. He resolves disputes through litigation, arbitration, appraisal, mediation, and negotiation. He primarily handles first-party insurance coverage and subrogation disputes involving energy, property, power, engineering, construction, and industrial risks that often include complicated business interruption issues. He also handles third-party losses, both defense and coverage. Prior to joining Zelle, he worked as an English solicitor with leading firms in London market. Jason acts as a commercial mediator for CDR. He regularly lectures and writes on emerging topics and key insurance law issues. And with Jason on this third talk, we will also listen to Deepa Sutherland, who is an experienced insurance litigator with experience in high-stakes international and domestic commercial litigation and arbitration, and e-discovery expertise across commercial litigation, internal and regulatory investigation. Since joining Zelle International LLP in May 2015, Deepa's practice has focused on rest of the world matters with an English law and jurisdiction element. She's working on some of the firm's largest matters, each with its own cross-border element. So I really thank all the speakers. The panel is very, very interesting. And as you can see, there is a fil rouge connecting the three talks. So as you know, we will have 15 minutes for each talk. I'll try to keep the talk in time. The first speaker is then Joana. Please, Joana, the floor is yours on main trends in the use of science in climate change litigation. General insights. Please, Joana.
Thank you, Mario, and thank you all the organizers of this conference. I already had a lovely time this morning chatting to the students of the course and had really excellent questions and discussions. So I was looking forward to this afternoon session. As you said, I'm going to give more of the overview, and then my colleagues will do the zoom in into different aspects of this conversation between science and law in climate litigation. So I will share my screen with you. I have a few slides, not too many. Wait, let me get this thing right. Sorry. Okay, good. So good afternoon. I want to give you a few examples that illustrate this role played by science in climate litigation. I think it's really interesting to see how this has evolved in the last decade. And so I will start with that, and then I will briefly discuss the central role that science is playing in climate litigation, And I will finish with a consideration about how the collaboration between scientists and lawyers is shaping the new cases and strategies. All of that in less than 15 minutes. So I hope you can follow, but I will try not to go beyond my time. So this is 2007, which feels like a long time ago, especially in climate litigation, because so much has happened since. And this is an exchange that took place in one of the most famous climate litigation cases you probably have already heard about, in Massachusetts versus EPA. This is Justice Scalia from the Supreme Court and James Milkey, an Assistant Attorney General of the Massachusetts General Attorney Office. And I will just read here this exchange. So Justice Scalia says, "Your assertion is that after the pollution leaves the air, goes up into the stratosphere, it is contributing to global warming." To which Mr. Milkey responds, "Respectively, Your Honor, it is not the stratosphere, it is the troposphere." And Justice Scalia responds, "Troposphere, whatever. I told you before, I'm not a scientist, ha ha ha. That's why I don't want to deal with global warming, to tell you the truth." So this exchange not only illustrates the complexities of judicial engagement with climate science, but it also shows how so much has happened in the last 10 years. So fast forward, and we are here in 2017. These two events that I actually attended in person, and I heard these two eminent scientists, Jeffrey Sachs, the economist, and James Hansen, the former NASA scientists, saying that basically the solution for the climate crisis, in their views at that time, was to, quote, "flood the courts with legal cases," as Jeffrey Sachs put it. And indeed, both Jeffrey Sachs and James Hansen have been directly involved in litigation. Jeffrey Sachs in the New York case against Exxon, and Hansen in the Juliana case. His granddaughter is one of the plaintiffs, the young lady sitting next to him at the COP. So it's really difficult to imagine that a judge would nowadays say, "I don't want to deal with global warming," as we heard Justice Scalia saying before. And I get now to 2018, to another important case that is still ongoing, one of those cases that has been brought by a number of cities and states against the oil majors. And here we have a judge, Justice Alsop, convening a climate change tutorial where he was explicit, and this is a quote from him saying to the media before the tutorial started, saying the poor judge can learn some science. So you can see how the judge then has a completely different approach, and not only he is dealing with the case, but also he wants to learn about the science. And for this case, they invited a number of scientists, including Miles Allen. If you were listening to the last plenary, you heard probably Miles Allen talking about his experience, talking to this judge, and also preparing with the lawyers to give this climate change tutorial. And I think this is a clear, it clearly shows how so much has changed, and the fact that not even the carbon majors, and Miles Allen said that in his talk, these companies do not challenge anymore. So this is a quote from the Chevron lawyer saying, "Chevron accepts what the IPCC has reached consensus on concerning science and climate change." And this has been really much the rule throughout litigation around the world. So this shows us that there is this common understanding now, and that not only the science of climate change and the IPCC in particular is being acknowledged and recognized, but also that it's playing a central role in climate litigation. So we see now how courts throughout the world are readily accepting scientific evidence, and also that this has influenced in some of the ways the court will approach and decide a case. For instance, accepting that has been critical in determining standing. Increasingly also, the courts are willing to attach legal consequences to governments that fail to step up, as we saw in the Urgenda case. What we haven't seen much yet, and I'll get to that, is that we haven't had courts recognizing the causal link between emissions and harms. And I will finish my talk with some notes on this aspect. So at the same time that there is that recognition and acknowledgement and acceptance, we can also see how the role of science in litigation is changing. And we still need to observe what this role is and what is going to happen. I'm citing here a paper that was published a couple of years ago on Science by McCormick and colleagues. And what they did was a systematic investigation of the role of climate science in federal and state litigation in the US. And they found at the time that only 2/5 of cases had really dealt with climate science, but that the decision in most recent cases had tended to explore climate science more thoroughly and more openly than in earlier cases. So I think this is really something that we can observe happening in most cases throughout the world now. What has happened also since is that novel legal theories are emerging and that these have increased the likelihood of success. So Annalisa will talk to you about the role of human rights, international human rights law in climate litigation and how that has strengthened the arguments and the chances of success in a number of these cases. So I'm getting to the end of my presentation, and the argument that I wanted to make is about how scientists and lawyers are collaborating. And this has been really crucial to climate litigation. My point here is that we have a lot of science being produced. There are thousands of papers that are reviewed by thousands of scientists for the Ipcc, but that doesn't necessarily mean that these findings can be easily translated, understood, and applied to cases. So what is crucial there is that there is this collaboration. And I have this quote here from Dennis Van Berkel, who is the legal counsel in the Urgenda case. And Dennis wrote this short article in Nature as well, saying, "I know that science is instrumental in arguing these cases." And Dennis knows that because science was instrumental in the Urgenda case. It was instrumental in the argument that they made about the fair share. So assessing this fair share of reductions in the context of the case became both a legal and a scientific issue, and one that was very much advanced by this collaboration between scientists and lawyers. There are other important areas where this collaboration can be important. For example, when you look at the argument that governments will often make that, that you can use negative emissions to address the climate crisis. And again, here we see how you might need to bring in climate scientists to show that maybe there are also risks in, for example, reforestation or extracting energy from biomass and other carbon capture technologies. So this collaboration is already taking place, and I can see how this will continue being very important. Perhaps the most clear example where this happened was the Rick-Heady study, the carbon major study that was published in 2014. And what this study was very important for was that it showed that there was a relatively small number of companies that responded significantly for emissions. And with that list, it was possible for many litigants to justify why they were filing cases against those companies. So we see a number of cases that immediately after the publication of this study were filed directly, explicitly, or not always referring to the paper. You can see here in this graph, I think it's quite obvious. See if you can look at the 2014 mark and what happened to litigation against carbon majors after 2014. So really being able to prove that there was a reason why the case was being filed against those companies was crucial in this broader litigation movement. the last example I want to bring of how this collaboration has been important is not just on these cases that seek accountabilities, such as the ones I mentioned against the carbon majors, but also, sorry, the ones, well, I'll get there. So the cases that seek accountability, but also the cases that are trying to move these companies into a different future. So these cases, while they are not asking for compensation for loss and damages, for compensation for losses, they are also importantly based on science, because you need to make a clear argument and justify why that transformation to 1.5 is important, what it means, and what it would mean not to make that shift. So just to finish, I want to cite this very recent paper that was published 2 weeks ago in Nature Climate Change by Rupert Stewart-Smith and colleagues, where they confirm, I think, these two arguments that I've made in this short presentation. The first, how science is important. Second, how the collaboration between scientists and lawyers is essential for these cases. And they also make a third argument, which is the one I want to end with, which is the fact that to a large extent, the cases so far filed are not referring to the most up-to-date, the state-of-the-art climate science that already exists. And this might mean a reduced chance of success, for example, in cases. So what Stewart-Smith and colleagues did in this paper, they looked at 73 climate-related cases across 14 jurisdictions where there were in liability cases. So these are lawsuits that made claims based on the causal relationship between greenhouse gases and losses. They're looking into attribution science and how attribution science can contribute to those arguments that make the causal link evident. So what they concluded in this study is that the evidence submitted lags considerably behind the state of the art in climate science. So this shows how first important it is to bring the science, but also not any science. You need to bring the most up-to-date state of the art, and to be able as a litigant to translate what that science is concluding into a way that is useful for the judges, for the courts to make their assessment of the case. So that all probably makes it clear how lawyers need to understand, have at least a basic understanding of the science, how scientists need to have at least a basic understanding of the law and what is needed for these cases, and that by having this collaboration between one and the other, and also with judges, by scientists collaborating and explaining to judges, we can see how these cases might progress and perhaps even reach some higher level of success in the near future. So I finish here, and I am looking forward to listening to the next presentations and to the Q&A. Thank you.
Thank you, Joana. Thank you. We will take the questions at the end of this session. So please take note of your questions. I'm sure you have many. Very interesting presentation. And now I invite Annalisa Savaresi. Remember, she's Associate Professor in International Environmental Law. She will talk about the use of science in human rights-based climate change litigation. So it's one of the two aspects we will listen on now. Please, Annalisa, the floor is yours.
Thank you very much again to Santana and Bickel for inviting me again. I seem to be a regular visitor these days. Hello, especially to the students that Joana also mentioned, whom I had the pleasure to teach there the last couple of days. My task this afternoon is to focus specifically on the use of science in human rights-based climate litigation. As it was mentioned, I've looked at this specific aspect for a bit of time together with Joana, and I will refer to a paper we wrote together quite recently to provide some data to the audience to understand why this litigation is special, if you like, bearing in mind that the usual features apply to this litigation as well. This includes the fact that it takes time and that it doesn't provide immediate answers, and that, like any other litigation, and this is maybe an important point to make on the paper that was just mentioned, like any other litigation, it looks back. It looks at what has happened up until the date of application. This is the nature of court cases. You draw the line somewhere, and that line lies on the date you submit your application. Now, what is important for us to do first and foremost is to define human rights-based climate litigation and the role of science in it. And in this connection, I draw on the definition of the paper that I've just mentioned, which I wrote with Joana. So what do we define in this paper as rights-based climate litigation? Simply speaking, it's any litigation that concerns matter of either climate science or climate policy and action that is based in whole or in part on human rights. And this is a little bit different compared with other litigation, because we're not only talking about court cases, but we're also talking about non-judicial complaints before human rights bodies at the national, regional, or international level. This is something special about human rights law. This is why, to be honest, environmental lawyers have long used human rights, because it provides additional avenues to complain against state and increasingly corporate action. So what are the numbers? How many of these cases are out there? In the paper with Joana, we counted 112 cases that were filed around the world. We accept that the data we have is not complete, and there is likely to be many more than these. Nevertheless, we relied on the usual climate litigation databases, and you have to look nowhere further than Joana's reports. She has been writing on this litigation for quite some time to find about the data and where it comes from. What I would like to say about human rights-based climate litigation is that it's largely filed in Europe, increasingly in recent years. The vast majority of rights-based cases have been filed recently. However, we are looking at a very small fraction of climate litigation when we're looking at rights-based litigation. In the end of May, the climate litigation database listed almost 2,000 cases, and of these only 112 were based on human rights. So we're looking at a very small fraction of what we call climate litigation. And what's special about these cases? As Joana said, these cases are particularly sexy right now. They have been very well covered by the media. Some resonant victories like Urgenda or Milieu Defensive were argued on the basis of human rights, not alone, but in combination with other sources of the law. And this is what makes the issue particularly interesting from the perspective of lawyers. Now, I will not bore the scientists here with the details, but what I would say is that in the context of this litigation, science has been used in what I would describe three main ways. First of all, and this may seem obvious to scientists, but in law, it's important that we demonstrate what we claim to the judges to establish that there are serious risks of human rights violations. And this was done famously for the first time in the Urgenda case, in a human rights case, in the Netherlands. Now, for the first time in 2015, but as we know, this decision has been appealed and won again by the applicants up to the Supreme Court level in the Netherlands. So the applicants successfully relied on climate science to argue and persuade the court that climate science demonstrates that climate change poses risks to the enjoyment of human rights that are protected in where? In the international treaties concerning human rights as well as in the regional treaties like the European Convention of Human Rights, which are translated into the law of the Netherlands in this case. So what has been done in Urgenda can potentially be done in other states where the same kind of international and regional obligations apply. And indeed, as you may not be surprised to hear, replica cases have been brought on similar grounds in other countries, with important distinctions. Lawyers always like to remind the audience that transplant is possible with variations because legal systems are not exactly the same. And therefore, these kind of arguments need to be tailored to the judicial system you are working in. The other important use of climate science that has been made in this case law is that to fill in with content states and corporate duties or obligations under human rights law. What does that mean? It means that once the courts are satisfied that climate change poses risks for human rights violations, it threatens the enjoyment of human rights, we also need to understand what to do about this. And this is exactly the other important role that has been played by climate science. Why? Because, again, courts in the Netherlands used scientific reports produced by the Intergovernmental Panel on Climate Change to determine how much emissions had to be reduced, first by the Dutch state and then by Royal Dutch Shell. The latter operation, as you will hear in the next presentation, I'm sure, is particularly adventurous from the perspective of a lawyer, but nevertheless succeeded, at least so far. And this is really important because it really shows how climate science may be used in an alternative, progressive manner by courts in order to determine specifically what corporations should do in order to tackle climate change. And finally, climate science has been used. We don't know the outcome of this complaint yet, but climate science has been used to establish causal links between emissions and human rights violations. Again, I provide here an example, and it's the Saki complaint brought by children, including Greta Thunberg, before the UN Human Rights Committee on the Rights of a Child. In this complaint, these children are not trying to persuade a court. This is an international human rights body, but what they are trying to do is to have the committee to establish that there is a causal link between emissions on the one hand and human rights violations on the other, and specifically of the rights of children. This is yet another example, and I don't mean to be exhaustive here, but just to show you how the applicants in the quote that you see on the slide formulated their argument. Whether or not the Human Rights Committee, the Committee on the Rights of the Child will buy this framing remains to be seen, because unlike the other two cases I mentioned, this complaint has not been decided yet. Having said that, similar arguments have been made elsewhere and successfully so. It is possible that the committee will be indeed persuaded by what the children are arguing in their complaint. Now, what does this lead us to conclude? What I would say is that we should not lose sight of the big picture of climate litigation and the fact that science plays a similar role in all climate litigation. And we have to be careful in not overstating the differences of rights-based litigation. After all, Urgenda was not initially framed as a human rights complaint. It was framed as a tort-based complaint with some human rights nuances. And then it turned into a human rights complaint as it got decided by the courts. So it's important not to overemphasize the differences. Having said that, human rights law has some advantages for litigants. Why? Because on average, I emphasize this expression, the burden of proof is lighter in human rights-based complaint vis-a-vis tort law-based complaints, for example. This is a clear advantage and explains why human rights law is often used by environmental applicants, not only in relation to climate change, but also in other contexts. In this connection, I've already mentioned there are human rights bodies that can be used by applicants that are not available if you don't formulate your claim in human rights terms. And these human rights bodies typically are less formalistic about the use of sources and therefore more amenable to consider scientific reports, great literature that are submitted by the applicant, more so than formal courts. Even so, courts in the Netherlands have shown us that even formal courts are becoming increasingly progressive both in their understanding of the law and in their use of the science. Other courts are taking notice all over the world. So replica cases are booming everywhere, and we can certainly expect to see more of this litigation in the medium term. So it's important that the scientists step up to this demand, if you like, from the lawyers to continue to produce science that is usable and useful in litigation. Joana mentioned Richard Heath's very important report. Others have followed that approach, and we are seeing more and more of this useful science. So let's keep talking and let's keep the conversation going, because this is a very important moment for scientists and lawyers to cooperate and work together. Thank you very much for listening.
Thank you, Annalisa. Thank you. Very interesting talk. And I have to admit that from being a scientist, it's a really different perspective on the same issue of the climate change. So really was really interesting for me to understand this perspective. And I have to say that we have this Q&A function which can be used already while the speakers are talking, because even though we have the Q&A session at the end, it is probably useful to write the question already now to keep track of all the questions. And at the end, we will follow the order for the discussion. Apart that we know that the first question will be asked by one of the students of the seasonal school. Okay, thank you very much. Now we move to the second aspect related to the impact and the use of science. And we go in the context of the corporate due diligence related to climate change. We have Jason and Deepa. They will give us the talk on the impact of science on corporate due diligence related to climate change. So I don't know who will start first, but the floor is yours.
Thank you so much for asking us to be part of this panel with such amazing speakers as well. We are coverage lawyers for insurers and reinsurers. So our approach to corporate due diligence is very much based on risk modeling and litigation risk for insurers. And that's very much the perspective that we'll be talking from, although I think we'll be following on and developing some points that Annalisa and Joana have already made. Just to pare it back, liability insurers have a duty to defend and indemnify their policyholders against claims made against them by third parties. Policyholders notify their insurers of such claims, and we are instructed on behalf of those insurers in many of the active carbon majors climate change lawsuits that are going on in the US and elsewhere. So for us, these are very much live cases, and we, so to speak, have a ringside seat at them. Now, we see the intersection of insurance and climate change litigation from where we sit. So from our perspective, when we talk about the role of science in climate change litigation, really based on our experience, we're really just talking about the role of experts in the litigation. And the role of an expert in climate change litigation is really no different to the role of an expert in any litigation.
So we thought it would be helpful just to give an example as to what this looks like. I'm going to go through a typical case that we've worked on where expert evidence was key to resolving the case. And here we had a refinery on the Gulf Coast, and in that refinery, caustic lubricant was introduced into, but not flushed out of the system, into 20 kilometers of piping in a newly built refinery. In the first 6 hours of operation, there were 29 spot fires. There was a claim put in, there was an investigation. The caustic leak, which caused corrosion in the system, was identified as the source. A lawsuit developed, and the insurance position was that there was a corrosion exclusion. And in order to demonstrate in a $300 million case whether or not a corrosion exclusion is going to apply, it's a scientific question. And lawyers aren't scientists, as we've already seen in some of Joana's and Annalisa's presentations. And so we turn to experts to help us on that. And before I talk a little bit more about that, I'm going to digress to a very specific point, which again links to something that Joana and Annalisa talked about, which is the jurisdiction and the forum is really important here. Because if we look at what corrosion is and how a corrosion exclusion might be treated, under English law, the court will require a temporal demonstration of corrosion. That means that it's a slow, gradual process. Under Texas law, it's a sequential process. It doesn't matter how quickly it happens. It's just a series of steps. And in that process, the speed isn't particularly important. So we're debating whether or not this is corrosion or it's not corrosion with the other side. We get their expert report. They get our expert report. Like good lawyers, we go through all of the drafts of their expert report in the exhaustive e-discovery that's very expensive for clients when they litigate. And between the fourth and the fifth draft of the other side's expert report, their expert changed the word in his report, which defined what the corrosion was. And that expert changed the word from stress corrosion cracking to stress cracking. And doing so meant that that expert turned his back on 116 years of accepted science. We were able to demonstrate with our expert, and we won the case. Now, I say all that because we're really at the sharp end of litigation. We do this sort of stuff. We work with experts and scientists on some really obscure niche topics all the time. It's just what we do every day. I really enjoy it, and Deepa does too. It's a lot of fun. And really for us, it's really important that everyone understands that not only in climate change, but in most technical cases, experts win cases. Lawyers rarely win cases. Facts remain important in law. In law, at least so far, it's not a post-truth world. So that's a really important point. The forum selection is really important. We have, in England, an expert's duty is to the court. In the United States, an expert's duty is to be an advocate for their client. And in most civil law jurisdictions, the court will have its own expert, which means the respective parties who are in dispute, their experts will be, their task will be to influence the expert who is actually interested and the court will be interested in. So that's all important stuff. And I think the forum selection point is important because not only do you have differing expert duties in different forums and in different courts and in different jurisdictions, but we also have a different interpretation of how that expert evidence might be applied, as in the corrosion example that I just gave. So how are we going to apply that? Well, we're going to look at overlapping some of the same issues that we've already talked about. We're going to look first at this first wave of US climate change litigation. And, you know, Joana referenced the quote earlier from Justice Scalia about Massachusetts and EPA, and that was an important decision back in 2007. The key cases really are the Comer-Murphy and Kivalina case. and those are essentially nuisance cases. Those were cases where communities along the Gulf Coast and in Alaska sued carbon majors for essentially damaging their infrastructure and their communities, and also for anticipatory future damage following rise of sea levels and increased severity of storms. Both of those claims were dismissed at a very early stage under a 12b6 under the Federal Rules of Civil Procedure because the plaintiffs were not able to demonstrate standing. And what that really means is that the claims were too remote. And when we look at that, what's happened between the first wave and the second wave of US climate change litigation, which began in 2018, is the development of science and the development of this expert evidence, which Joanne mentioned earlier, which is the Richard Head work from the Carbon Majors report in 2014. And this is why the second wave has been more successful. These claims are not being dismissed at an early stage. In 2018, there were about 13 key nuisance lawsuits filed in the United States. There's currently about 20 that are going on. Everybody's waiting for what happens in the Fourth Circuit to see whether or not these claims are going to be heard in federal court or in state court. Broadly speaking, most defendants would prefer to be in federal court, and most plaintiffs would prefer to be in state court. And these are all the cases right now in the United States that are making the news, and it takes up a good deal of what we're doing in our day jobs, so to speak, at the moment. And the reason that these nuisance lawsuits haven't been dismissed at an early stage is because, well, the science has developed. We're in a different place 10 years on, just as Joanna said. And part of the reason for that is because of the work of science that's done. There's also been a societal shift as well, that we accept that this is happening. If you want a clear update on any of this, the Cher Edling lawsuit keeps a fantastic log of all the current cases and claims that are underway in the United States for climate litigation. It's a fantastic resource. And I would encourage you to go there. They're lead lawyers on most of that for the plaintiffs. And this is what we're really talking about when we look at Richard Head's 2014 Carbon Majors report. We're looking at the historical emission data. And this is able to demonstrate who emitted what between 1750 and 2010, and to give them their historical share of anthropogenic greenhouse gas emissions, which means no longer are we able to question whether or not this is a remote claim and that a plaintiff can't demonstrate standing, which is why the second wave of US climate change cases have not been dismissed. So just to go back to some points that have already been sort of talked around a little bit, expert evidence in these kinds of claims, not necessarily in the constitutional claims, but in the tort claims that Annalisa was mentioned earlier, this expert evidence provides a basis for the tort claims by addressing the remoteness issue and the causation issue. And Deepa is going to talk to you a little bit about what that causation issue looks like when we move to the second limb of what attribution science is doing now.
When we apply that to climate change, expert evidence, as well as being able to quantify companies' emissions, really expert evidence now is trying to confirm the effect of climate change on specific events. So from the insurance perspective, we've always had hurricanes, we've always had floods, we've always had forest fires and other such catastrophes. The next step in attribution science is to identify the severity of specific events. And just some examples just that have made the headlines in the last couple of months. I think Annalisa referenced, there are so many studies coming out. And these next few slides are just an example of the sort of studies that are aiming to quantify the effects just in the last couple of months. And what's interesting, there was a study from Oxford University in February this year, which says it's a key piece of missing evidence in the Liua and RWE case. Now, that's an example of expert evidence at work in a current case. It claims to be clear lineal causal chain between greenhouse gas emissions and the severe flood risk from the glacial lake above Mr. Liua's city. It claims to be key new evidence, and that's going to be tested in court. So how the shift has happened in the last year has been incredible as well.
So these are all lessons that have actually been learned and forgotten both by insurers and reinsurers and corporate policyholders and the corporate world altogether. These climate change claims are essentially seen in the right light as long-tail pollution and environmental claims. They have a significant overlap in the way that they're going to be litigated because of the long-standing deception of carbon majors in the same way that tobacco cases were litigated. And it's going to have an impact on insurers and reinsurers in the industry and the corporate world in the same way that asbestos and MTBE both impacted and resulted in significant financial losses for insurers and reinsurers. The big difference between tobacco, asbestos, and MTBE and greenhouse gas emissions and hydrocarbons is that we can remove tobacco, asbestos, and MTBE from the food chain, and there's really no downside. I mean, I guess if you're a very serious committed smoker, that's different. But nobody needs asbestos to continue living. And right now, as Deepa is going to bring up in a little bit, we can't turn the switch off and get rid of all hydrocarbons. The thing about these nuisance claims and the other constitutional claims that are happening right now and increasingly successful, it's a very nice parallel to what happened with tobacco, which took 50 years from the first substantive lawsuit against tobacco companies until February 2000 before there was a meaningful decision against the tobacco companies. We've had probably 10 years of very real focused climate change litigation against carbon majors. I don't think that we have another 40 years on this clock. So, Deeps?
Yeah, so tying this just back into where we sit, talking to insurers, you know, we're real advocates of saying insurers are in a unique position here when it comes to climate change, because their exposure is twofold, not only as companies with their own investor risk, their reporting requirements and their shareholder obligations, they're also highly exposed to the financial implications of climate change through their underwriting and paying claims, both on the property insurance side, which actually already factors in climate change risk, but more so on the liability side, where insurers face potentially huge exposures added to the exposure of the duty to defend to pay legal costs. And that climate change risk hasn't been factored in as yet on the liability side. It is currently in the process of being quantified, and the biggest insurers are currently participating in stress tests. But really, it hasn't been quantified yet, and litigation risk hasn't really been taken into account because insurers have not yet paid out on one of these big claims. And of course, the huge exposure that they potentially face on the liability side raises a bigger question of whether climate change liability actually should be insured, and should insurers actually be softening the blow for emitters, which is probably a whole new topic. So the insurance industry certainly has an awareness, and we're seeing increasing pressure placed on brokers and insurers to try and quantify their risk. And there's an appreciation now that litigation risk from climate change must be seen alongside physical and transition risks as an integral part of their business. As I said, that's a shift because to date they have not really focused on the litigation risk because they've just won every claim so far. Sorry, the policyholders have won every claim so far. So, you know, insurance is often excluded from climate change discussions. We hear about banks and other players in the financial field, but we really don't hear much about the role of insurers. Whereas we would argue they're really a key stakeholder. They're one of the largest global industries, and indeed they underpin the economy. So their unique role, plus the size of the industry itself, really puts the industry in a really strong position to try and bring about some of this systemic change that we all want and we all talk about, and incentivize to transition and shape corporate behavior, which indeed are the aims of many of these lawsuits. So there's definitely opportunities, but there's also challenges. And we have to remember that insurance reflects the economy. And as Jason said, we can't just turn the switch off for hydrocarbons. And that may be perhaps where science reaches its limits in this case. You know, the comparisons with asbestos and tobacco reach their limits in that regard, because at present we all depend on hydrocarbons. So the insurance industry can certainly play a bigger part in incentivizing that transition. We also need to remember, though, that the structure of the insurance market really means that a few key players, the reinsurers, the biggest reinsurers, effectively wield the power here. So we won't really see any meaningful change until those key players basically change how they insure the insurers or refuse to insure the insurers for certain risks. Or, of course, we can see a change reactively when the industry suffers massive losses, which no one really wants to come to that. So that's how we wrap it up with insurance.
Leave everybody with this final slide, which was my favorite slide when we talk about climate change. A real life advertisement from Life magazine, 1961, an energy company which later became Exxon, bragging about their products. Every day melts 7 million tons of glacier. I'll hand back over to Mario. Thanks.
Thank you, Jason. Thank you, Deepa. And thank you all the speakers for being within your time frame. Now we can start our question and answer session. And as you see, there are already many questions in the Q&A panel, and you can keep writing on that panel. And we'll proceed as follows. First of all, I'll ask to Riccardo Luporini, who is one of the students of the seasonal school, to select one question from his colleagues. That will be the first question to open this session, and then I'll ask Ivano to help me in moderating the remaining questions. We'll try to go through all the questions in the panel, so you can keep writing there. And first of all, Riccardo, you can start.
Hi everyone, and thank you very much. I'm sure that the participants in the seasonal school on climate change and international law here at the Scuola Sant'Anna are very, very happy for this great opportunity to address their questions to the expert that we have here with us today and tomorrow. For the moment, I have one question by Chiara Scissa. She's a participant in the seasonal school. It is actually a broad question. You can read in the chat. She says, well, the ultimate question is actually, what role can climate science play in persuading states to take on their responsibilities towards climate change in an efficient and comprehensive manner? So I think that maybe as we are talking about states here, Joana can first answer in a broader way, from a broader perspective, and then maybe Annalisa can give us more precise answer with regard to human rights-based climate litigation. Thank you.
Thank you, Riccardo. So Joana, if you want to start.
Sure. Just to make sure I understood the question, it's about cases against governments. What specific aspect? Do you mind repeating, Riccardo? Sorry.
Sorry, Joana, if you want, you can also read the question in the panel. Is the first one on the open question, so you can take that as a reference. I'm saying that for the benefit of all the speakers, so you can read all the questions there. We'll try to answer to all of them if we manage within the next 30 minutes. So, Joana.
So I see. What role can climate science play in persuading states to take on their responsibilities towards climate change? Okay, thank you. I think the way I would approach this question is that it has been very important in a number of these cases filed against governments for the plaintiffs to demonstrate that, well, first, what the problem is, what are the causes of the problem, and what is the responsibility of states in addressing. So if you look at Urgenda, for example, the discussion around the fair share, as I mentioned briefly, was crucial to the case, because against that that argument is that line of defense that is a drop in the ocean. So the drop in the ocean argument from defendants has been one that for many years was considered as an important obstacle for these lawsuits. And similarly, we saw that in our agenda, and we would imagine you could also see this in the Irish case. So many countries that respond so little to emissions and then therefore question these lawsuits based on, well, why us? Why not others? What can we do? And this is where the science has been very important, because with the science, it was possible for litigants to demonstrate that the science combined with the human rights argument, it was possible to demonstrate that, well, it doesn't matter if it's still a drop in the ocean, but you still have to do something about that because the problem is happening, the threats are huge, and we're talking about human lives. And this is another very important reason why human rights gave teeth to this litigation, because it was not just a matter of closing down, phasing out coal, but it was a matter of then saving human lives. So I think that this is where the combination between the science and human rights have been really crucial. And sorry if I'm already entering a bit in Annalisa's answer, but it has been crucial in making a strong argument in these cases against states, establishing what then became now the duty of care, the standard of care that governments have to observe in protecting their citizens. So I'd probably stop here and then give others a chance to answer to this very good question. Thanks again.
Thank you, Joana. I don't know if Annalisa wants to add something. I'll ask you to be brief in the answers, to answer to many questions. We have already 11 open questions, and I say also to the audience, to the attendees, if they want, they can use the like function on the question, because we can go in this order. We'll try to answer first to the questions with more likes, and then we'll go to the others. So please, all the attendees, go through the question list and choose your question, also to avoid overlapping many questions on the same argument. So Annalisa, please, the floor.
I'll be brief because Joana has already said many important things on this topic. What I'd say is that scientists have not realized that their work could be used in litigation for quite some time. They've only woken up to this reality recently for the reasons that Joana has mentioned, and therefore now the game has changed. And I think they have realized that their impacts can be quite significant, even though we have to appreciate that litigation is a slow-moving animal. It takes years, and the changes it produces are incremental. So I will return to this point later, but I think it's a very important point. It's part of a concerted strategy. It's not one thing on its own that science can do, but clearly it's woken up to this important role that it can play also in this context.
Okay, thank you very much. I then ask to Ivano to help me in reading the questions and direct to the right speaker. So please, Ivano.
Yeah, hi, thanks again to everybody, because it was really excellent presentations. So I'm really curious to start with this question from a scientist who's been cited already like a few times during these two sessions. So he's Rupert Stewart-Smith. And he asked a question which I think I will leave to you to decide who is going to reply. So what advice do you have for developing fora for engagement between the scientific and legal communities that ensure that first, lawyers are able to request scientific evidence that evaluates the factual basis on which claims are made, and second, scientists are aware of the needs of the legal community, but which doesn't undermine the independence of scientific evidence This is a very long question, so if you want to start already from this.
Okay, so I ask also to the attendees if when they write the question, if they can also specify who would be the speaker they'd like to the answer from. But being a general question, I see Jason as his end on, right? And so please, Jason.
Yeah, I think this question is right up our street as sort of litigators who regularly work with scientists and experts, and happy for other people to jump in, of course. But you know, what I would say to Rupert's question is that, you know, when we take on a technical case, you know, it's important that we find the right expert. And we've worked with all kinds of obscure experts in any number of things. You know, the number of metallurgists that we've worked with is off the chart. A lot of power people, and you know, if you want to know about electrical switches, Deepa could probably write a PhD on it right now, to be honest. So I think, you know, the engagement between the scientific and the legal communities, there are a number of firms who essentially sell their wares as experts, and you establish a reputation. And you know, Rupert, if one of these cases comes up, you know, and it's a coverage question about, you know, climate change stuff, you know, it might be that this very interaction will be part of the networking that would take place. And so I think it's important for scientists and lawyers who are interested in a particular field to get to know each other and to network in situations like this and elsewhere, because experts win cases and you've got to have the right person to advance your case. We spend a lot of time with these folks, and how you present their evidence and how they're going to play in front of a jury, a court, or an arbitration tribunal is all really important. So hope that answers some of the questions that are there in you're looking at. And I would say independence is very important. You can't be you know, biased. You need to be able to present your information in a neutral manner. Otherwise, you're going to come across as somebody who's trying to sell a position that maybe isn't accurate. And from where we sit as lawyers, we only want somebody who's actually going to tell us the actual truth. And if the truth is that our position is legal or scientifically wrong, then we should be telling our clients, you need to settle because this isn't going to go your way on the facts.
Thank you, Jason. Being such a broad question, I don't know if any other speaker want to add something to what Jason said. Okay, so we can move to the next question. So, Ivano.
Yeah, the next one, I see a lot of thumbs up here. So another question from some of the participants to the Sant'Anna Seasonal School. So this is a little bit outside the core topic of our conference, but is also very interesting. So the panelists showed the transposition of climate change science to the world of litigation and corporate administration. But what about the transposition of climate change science to the world of policy making? The EU Green Deal is an example of how this can influence political intent. The French amendment of Article 1 of the Constitution, UK climate law, another example. What outside Europe? Can the panelists elaborate a bit more on the climate change science-oriented policies that might have an influence on litigation and corporate administration?
Okay, very, very broad question. So I don't know, Joana, Annalisa, maybe one of you.
I can try to answer. So if I understand the question correctly, it raises the importance of science also influencing policy. And that's something that has been occurring for a long time. So think about the Ipcc. Why was the Ipcc created in the beginning? Well, of course, it wants to consolidate the science, but also it wants to communicate to policymakers the synthesis of all that science that has been produced. So it has at the very origin of it that understanding that policymakers need to just to know what the science is saying, and because it's impossible to track that, even to the experts, it's really hard to track everything that is happening. There are 700 authors only, I think, in the IPCC report itself, and the IPCC report then is condensed into that summary, which is probably what most people read, and you expect policymakers to read, which is the summary for policymakers. So you see how there is that concern for quite some time already that policymakers understand the science. That has been important, but it hasn't made the difference that we wanted. Look at the gap between what we know and what has been done. And this is kind of bringing back to the topic of the presentation where litigation came in, because it has a lot of its motivation on the fact that the science is available, policymakers know about that. Have they legislated enough? Are they regulating as they should? Are they enforcing that legislation? If the finding is that, no, not quite, then an alternative has been go to court. So kind of, I think it brings all together in this way, but definitely the importance of communicating and how communicating the science is very clear. It has to be easily understood to a wider public and to the policymakers.
Thank you very much, Joana. I'll go to another question, Ivano.
Yes, from Caroline Foster from New Zealand. This is already directly to someone, to Annalisa. So, dear Annalisa, might the European Court of Human Rights turn to the precautionary principle in dealing with scientific cases? So she said, I hear murmurings about this. And she also wrote a book from Cambridge University Press on precautionary principle, science precautionary principle, international courts and tribunals. So she asked also, when you say the burden of proof is lighter in rights cases, do you want to elaborate further on this? For example, in which legal system is this the case?
Thank you very much, Caroline, for those questions. They are big questions, but I'll try to be quick. Imagine if urgent had been argued only on the basis of tort. Would we be talking about this great victory today or not? In the European system of the European Convention of Human Rights, the European Court of Human Rights has been constant in its jurisprudence, in acknowledging violations of human rights, even in cases where, from a tort perspective, no harm to persons or property had occurred. And this is exactly that junction where human rights law is so useful in environmental cases. This is not something we've discovered with climate. We've known this for a long time. I would argue that we've been too slow in climate in realizing this potential and in using it in climate litigation. And this is why, to be honest, I believe personally that the Dutch courts jumped on the human rights bit of the Urgenda argument and kind of turned on its head the arguments that have been submitted by the applicants. This is my reading, and of course you may say I'm biased, but the vast majority of human rights cases concerning climate are being brought in Europe and have been decided in Europe, and this is where I think we are seeing these developments. Whether there will be similar developments elsewhere, and especially in common law jurisdictions, and I here note the question of Mark, we really have to bear in mind the specificities of legal systems. As I said, we shouldn't just assume that the same arguments would fly in front of very different courts, as the Irish cases have already demonstrated. Now, precautionary principle. Again, it's easier in Europe, I'm afraid, because the precautionary principle is part of the acquis of the European Union, and as such, it's used and usable in courts of law. So if the precautionary principle is going to win, it's definitely likely that this will happen in a European court.
Thank you very much, Annalisa. Ivano, please.
Yes, and there is a follow-up question to this Caroline's question. So from Francesca Leucci, drawing on the statement on the lighter burden of proof in human rights-based litigation, the subsequent question is why don't judges feel comfortable with basing the decisions on scientific consensus? Is that happening because science is not codified in positive laws?
So I think, Annalisa, you can
I don't want to hijack the scene. So I'll be brief because maybe Jason and Deepa or Joana want to come in. But what we need to really understand is that we are looking at an area of legal practice which is in its infancy here. The law on climate change is new. The litigation is born yesterday. I know that to the years of climate scientists that have been working on this for decades, this is frustrating. But the reality of the legal practice is that it is incremental and it builds on the practice that came before it. And in this connection, this is where cases like Milieu Defensi and Urgenda are really important because they have set foundations upon which others are quickly building. But litigation of this kind also informs lawmaking. And this is even more important than litigation in itself. We saw that the Urgenda case led to the adoption of a climate law in the Netherlands. We have climate law being adopted now in the EU. And the thing is that this is not to say that these states or regions were not doing anything before, but they are now developing legislation that kind of factors in the practice of litigation, and this is really important. So, we have to see the glass half full sometimes, not only half empty.
Okay, thank you. Jason, do you want to add something?
Yeah, I would say litigation is a blunt tool, and it doesn't really provide, particularly in the tort cases, an elegant solution to climate change. The handful of cases that have been brought in the second wave of climate change lawsuits in the United States that have been dismissed have often been dismissed by judges who agree that climate change is happening and that the plaintiffs have largely proved their case, but there's not a basis in tort law that's going to allow them to make a decision in favor of in the plaintiffs or the claimants in those cases. And what we're seeing right now is we're seeing a tension, and what ultimately happens in this tension, like it has with asbestos and MTBE and tobacco, is that we have a series of claims over a long time, and eventually one of these judges jumps the shark, right? And they say, this just isn't fair, and I'm going to rewrite the way tort law works. And when they do that, lots of things can happen outside of climate change, outside of the issues at hand, and that's the real concern. I think Annalisa is absolutely correct. I think that these lawsuits are really about policy, because right now policy solutions are failing and they're not getting implemented. And so the litigation, even the tort litigation that might be unsuccessful, it's completely changed the way that climate change is seen by the public. It's a movement. And I'm not surprised that tort law isn't necessarily catching up with the fairness principles that we might all agree and adhere to, particularly those people who've been working in this area on the science side for decades.
Thank you, Jason. Thank you, Ivano.
I think that I will take a question.
Wait. We lost you. Ivano? Sorry, Ivano, we lost you for 10 seconds. Can you repeat, please?
Okay, can you hear me?
Yes.
Okay, perfect. So probably another question for Jason, but we put in the already answered the question, so I just do before we forgot. So this is from Alison Baker. We have seen class action where the litigants are children, so intergenerational equity, or human rights, intergenerational equity. But what about other specific classes of individuals suffering impact from, such as a group of farmers suffering reduced yield in agriculture and therefore economic loss due to climate change impact?
I saw this question come up, Alison, and it did really resonate with me. We end up with a lot of liability cases, and forgive the bluntness, but I typically call them, you killed my grandma cases. And we're seeing a lot of those cases out of the Texas freeze right now, where the power companies weren't able to provide power to people, and people suffered harms, and people's grandmothers died. And if you saw in the list of examples of attribution science being linked to specific increased severity of specific incidences. One of those was a 37% increase in deaths due to climate change related heat spikes. And so, yeah, I see that as a ripe area where somebody can come along and pick one of these subjects. And for example, to take the increased deaths because of heat due to climate change and say, you killed my grandma because of the heat spike because of climate change. And that you get a class action. And that's what these lawyers do, particularly in the United States. So I see that there's a lot of creative ways that lawsuits can be advanced. I don't think that it's just about carbon majors necessarily. And it's certainly not just in the traditional tort deception model that we're seeing with nuisance claims primarily brought by municipalities. I think that we're going to continue to see these claims evolving and we're going to see a lot of creativity in these kinds of claims. So yeah, I mean, we could sit around and brainstorm this stuff, email me offline. I'm sure that would be a lot of fun, and we can put it all to our insurance clients and scare the hell out of them.
Thank you, Jason. Thank you. Ivano.
Okay, now a question for Deepa from Chris Hilson. So Deepa, you say there is a question of whether it should be insurable, but is it currently covered? And would coverage exist for fossil fuel companies if they have not acted in good faith? Or would the argument be that the insurance companies must also have known about these risks a long time ago?
So the short answer is insurance is only there to cover unforeseen circumstances. And if the evidence, which is increasingly emerging from companies' own records in many cases, shows that companies did know expected and intended consequences are not covered under insurance policies.
Nice. Very, very impressive answer. Because what should be considered unforeseeable, it's really difficult to understand for me. From thinking to extreme events, you know, not just thinking to the slow changing events like temperature, other type of things. But I leave the questions to the audience. So Ivano, please, can you select another question?
From Mark Ortega. So we have a question from Annalisa, a question from Joana. So let's start from Joana because Annalisa was the last of the two. So thank you for your presentation. Of course, you mentioned that the courts are developing novel legal theories which strengthen the chances of success in these cases. Could you please share what are some examples of these novel legal theories being developed and how these increase the chances of success in these cases? Is, for example, the public trust doctrine one of these you're referring to?
Yes, thank you for this question. So I was referring to a number of areas that have been explored recently in climate litigation that have seen better, more success or higher, perhaps, chances of winning than the liability cases. And so, of course, there were the human rights, international human law and human rights cases that we've already touched upon, but maybe I would now emphasize the cases that are grounded in commercial law and company law, and that are identifying, and it's something we discussed today in the summer course in the morning, the greenwashing cases. I think these are really interesting examples where you don't need the most advanced science to prove that there is an obvious inconsistency between the discourse of companies and the action that they take. And so these are, of course, in many countries, areas of law that already existed. Almost every jurisdiction will have a law on fraud and consumers protection to protect exactly consumers from greenwashing. What we are seeing now is how these are being used in climate litigation and how powerful they are, because not only they require much less technical expertise, also some of these cases have been brought in other courts, also not in courts, but for example, in the OECD focal points that countries will have, and this allows these cases to be decided with more speed. So you avoid the lengthy, uncertain results that you might have in courts, and you get say not legally binding, but you get at least some decision from an OECD focal point, which confirms that there has been greenwashing. And just the risk of these cases, it's something that's in the previous panel was discussed, and I think it's a very important point to raise here, which we haven't yet, is that that litigation risk in itself can create change, and that therefore the risk of being sued for greenwashing is already making a number of corporates think twice about their advertisement campaigns, which before they would sell themselves as very green, very renewable, very etc., carbon neutral, and now the risk of that litigation has already, I'm sure, shifted that behavior. So I think that this is one of many examples of new areas of law that have been used in climate litigation and that can improve the chances of success in some of these cases.
Thank you, Joana. Ivano, I see there are 10 open questions, and we have 7 minutes left. So you have a very important responsibility here to select the last 3 questions for our speakers.
Yeah,
I
will choose wisely. So this has a lot of thumbs up, if we can say. And is again Mark Ortega. So this is for Annalisa. You mentioned that on average, the burden of proof is lighter in human rights-based climate litigation as compared to tort-based complaints. Could you please share more why this is the case? I ask because, to use a common law concept, the standard of proof in a non-criminal case is typically to prove a disputed fact on a balance of probabilities. Does the lower burden of proof arise in human rights-based complaints? Arise because the disputed facts which needs to be proved is different in both types of cases. And then you put an example, but for causation of the cases where liability is sought for specific harms versus proving the risk of human rights. So yeah, this is for you, Annalisa.
Yes, I think I have already answered this question earlier when I answered Caroline. I kind of bundled them together. Maybe you didn't hear that. What I said is that there is a rich body of case law by especially the European Court of Human Rights, where this link is made by the court. If the same applicants had tried to sue the governments as opposed to the corporate actors, depending on the facts of the case, on the basis of tort law, they may not have succeeded. In all likelihood, they wouldn't have succeeded, but they were successful on the basis of human rights. Now, would this argument fly in England? My answer depends. It depends on a number of factors, and I have to confess, I'm not familiar enough with the practice in English courts to say how they treat this case law by the European Court of Human Rights. I know that in many European countries, this is very mainstream or has become mainstream thanks to the influence of the European Court of Human Rights. And therefore, I recommend that Marco takes a look at the manual on human rights and environment prepared by the European Court on the basis of its past case law. This is under review. We will soon have an update of that, so keep an eye out for that, because it compiles of the practice of the court on this matter, amongst others.
Thank you, Annalisa. Ivano.
Yeah, from Eric Rao. So can any of the panelists speak about litigation on secondary effects from climate change, for example, harms due to the electric utilities igniting fires or causing outage? So.
Sorry, Ivano, I'll just jump in real quick. Those are really addressed in a lot of the nuisance claims.
Yeah. Probably you can select another one.
Okay, so yeah, there is a long one. I can just try to, but I lost it. Okay, just try to read the last part of this. She's talking about COVID, Rafika Rosli. So COVID-19, a political crisis, dominating global news headlines. The truth is the impact can never be overstated because climate issues are related to so much more. And so she said the consequences of emitting greenhouse gases into the atmosphere are way bigger than most of us knows. So what is your view in relation to the efforts that we can do so that this knowledge can be used in educating our judges? So this is interesting, that climate change is a real threat and not just a boring stuff and must be taken into consideration when giving his or her decision. So connect with Joana said, also what Jason said.
Yeah, I think Joana, if you want to answer to this.
Yeah, I can try to answer that. Thanks. I think what is really important about what this question asks is think about the judges and what maybe how we need to understand what judges have already been able to do and maybe what they need to be able to respond to this influx of climate litigation cases that are going to reach courts everywhere in the world. So judges are used to dealing with, tax law, with pipes that fail, with a number of technical issues. I don't think climate is so different from so many topics that these judges have to deal with. It's hard to be a judge, especially if you're not sitting in a green tribunal, for example, where you can specialize in something. If you're a judge that has to deal with family law, criminal law, tax law, you have to deal with so many knowledges and areas of often science that you don't quite know. So judges are somehow able to do that. But I think that the idea of green tribunals or tribunals that are specialized in environmental and climate comes alongside with that is an important decision that many courts have already taken, and that helps the decision of these cases in that judges are more familiar, they have received training, they're not afraid of taking decisions, they know about the importance, they know what courts have decided elsewhere. And that has been so important in climate litigation because it, as we observe, it has become a transnational movement, one that judges in Australia are reading court decisions from Ireland and from the Netherlands. And this is easier if you have judges that have the time, the mind space to look more closely at this type of cases. So maybe, these judges will have challenges if they are not in those specialized courts, but it will become more and more common. So as I said, I don't think that it will be possible for judges to run away from deciding these types of cases. Even their children won't let them. And the newer generations of judges who grew up knowing about this problem won't be able to run away and sleep well that night if they decided that this is a political question.
Thank you, Joana. Thank you. Ivano, please pick the last question because it's already 6:30.
Yeah, I think that we are already at the end of this. So let me see. Yeah, the last question is from Shirley. Giving rivers their own legal rights. How will giving rivers legal rights help countries reduce the carbon emission in support of nationally determined contributions? This is much broader than, but I mean, if someone want to reply.
So Annalisa, please.
Litigation based on the rights of nature has also been around for a while. It's not prominent in the context of climate litigation, although there are some examples of courts making reference to nature's rights in that context in their decisions, for example, in Colombia. This tends to happen in those jurisdictions in those countries where such rights are recognized. Nature's rights are not mainstream, so they are not a very usable tool yet. They may become more so in future. The key issue in all legal practice is whatever works. So we have to wait and see. We are, as I said, in the infancy of this litigation still. We have loads of cases, but comparatively speaking, we don't have a lot. And we will have to wait and see what are the legal arguments that are winning, and they will become mainstream across all states, to be honest, in a matter of a few years' time.
Thank you, Annalisa. Thank you for your short question, and thank you to everybody for the interesting questions. I think we need to close this panel. I thank all the speakers. I thank the attendees. I thank also Christine and Roberto for organizing this interesting panel. Tomorrow, the workshop will continue with other two interesting sessions, one on the role of science in national climate mitigation, and the other on the role of science in international environmental and climate change litigation. And at the end, at 5:30, we will have the concluding discussion on the evolving role of science in climate change litigation. So it's really, was really a pleasure to participate to this panel. We'll probably meet tomorrow. I don't know if Christine or Roberto wants to, yes, please, Christine.
Yes, thank you very much, Mario. Thank you very much for your excellent way of chairing this panel. Thank you so much for the members in the panel, Joana, Annalisa, Jason, and Deepa. I think this was another excellent panel which brought out so many questions, so many issues, and indeed showed again, as Mario also pointed out himself, the language sometimes that you as scientists use, that we as lawyers use, sometimes we use the same term, but we mean something different, right? Insurers will talk about some unforeseeability, which for you scientists might be a completely different, or you would give a different answer to what is foreseeable or unforeseeable. So I think there indeed, this is one of the examples of indeed the language, the communication of how to transform scientific data into language that can be used by the lawyers and the judges. So I think this is extremely interesting and brings out very, very interesting points. So thank you again, Mario. Thank you to the panelists. Thank you for all the participants today. Tomorrow we will continue the discussions. Indeed, we will convene again at 2 o'clock Italian time, 1 o'clock UK time, and well, the rest of the world will have to figure out for yourself, please. Really counting on your presence. And indeed, the concluding discussions, I hope some of you will have time to be there again. And we can continue bringing the dots, trying to connect the dots again. But so tomorrow go on, and at 2 o'clock, we're looking forward to seeing you. Thank you so much.
Thank you. Thank you. Bye.